Good afternoon, Your Honor.
Good afternoon, Judge.
Fatuma Sichale, karibu sana.
Thank you very much.
Good afternoon, Mheshimiwa.
Good afternoon, Commissioner.
You are welcome. My name is Oluwande Evelyn. I wish you well.
Thank you very much.
Good afternoon, Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Good afternoon, Honorable AG.
Winfrida Mokaya, Secretary, you're welcome.
Thank you, Honorable Chief Registrar.
Very well, thank you for that introduction. Honorable Ojoo, if you could start by telling us your county and your ethnicity.
My county is Siaya. Ethnicity is Luo.
Very well. We'll start the interview, although we like to make it a conversation so that you can relax and we get the best out of you.
Thank you.
The water in front of you is yours. Anytime you want to take a sip, please go ahead. You have been on that seat before, so it's not very alien.
It's true.
Yes, so if you can start by telling us what really distinguishes you so that this commission should nominate you out of the 100 candidates that we are interviewing. We know you have had a long career as a magistrate, but we want to know what really teases you out as a person of high achievements, a person of integrity, a person of hard work, a person with unique experience and skills and innovation, so that when you are given this position of the High Court, you'll be able to help us with the challenges we are facing there. Challenges of backlog of cases. So when we engaged with the stakeholders, they told us to take people who can really work and people of integrity and moral probity. So you have 5 minutes to tell us who you are and what you have.
Thank you very much, Honorable Chief Justice and Honorable Commissioners. It is an honor to be here, and thank you for this opportunity. I do not take it for granted. My lady, I have reflected on the requirements of a judge of the High Court and taken into account the input by our stakeholders and members of the public who gave their views in this recruitment, that a judge should be a person who is hardworking, competent, knowledgeable, and has organizational skills that will enable him or her deliver on the mandate of the office. I align with these aspirations, and I wish to give my candidature and explain why I am fit for this position. My lady, in terms of skills and achievements, I wish to state that I bring 25 years of all-round experience as a magistrate. In that time, I have served committedly and upheld my oath of office in different stations across the country, serving and working with Kenyans from different backgrounds. I have also been head of station in different stations across the country. Currently, I serve as chief magistrate at Mavoko Law Court, where I am also head of station. At the court, I have inculcated and fostered teamwork among the judicial officers, the judicial staff, and stakeholders alike. And this has enabled us to have smooth flow of work and improved customer experience for our clients. In the last 3 years, I have led the team to clear a backlog of over 3,700 cases, while maintaining a case clearance rate of above 100%, and also keeping up with the high inflow of work coming in. As a team, our focus is always to have equitable distribution of work, and also staying motivated to avoid burnout. As regards my experience and values, my lady, over the years, as I've said, I have served in several stations across the country. I have been interpreting and applying the law, different statutes, touching on different facets, and this has enriched my understanding and knowledge of the law, and also my appreciation of the lived realities of our clients. I have mastered courtroom and case management skills that enable me to prioritize cases and adopt different approaches like court-annexed mediation and plea bargain to enable parties get quick resolutions to their cases and also to avoid backlog. I have held leadership positions, as I've said, and in that area, I believe I have excelled and left a legacy of hard work, high performance, and integrity over the years. And I believe, taking into account all my vast experience, skills, and organizational skills, I would contribute to the higher bench and contribute to the higher bench and lead to the fruition of the vision of the court, which is to be a model court in dispute resolution and protection of rights and liberties.
Yes, thank you. And looking at Mavoko Law Court, what measures have you put in place to fight corruption? Because you know the main cases in Mavoko is road traffic accidents, and I've received information that there's a lot of corruption. You know, people wanting, if they have been charged with traffic offenses, they go there and, pay money. In other words, describing Mavoko as a marketplace. Yeah.
Thank you, Honorable Chief Justice, for that question. Okay, I was not aware of that description, but what I would say is that as a leader, and in collaboration with the Court Users Committee and my Integrity Committee, we have put structures to deal with busybodies and brokers, particularly in the area of processing of bond, issuance of statements to accused or litigants, refund of deposits, just general complaint handling that enable us to suppress the blind spots for corruption. We have done that, my lady. And
anything specific about traffic offenses, because those are the majority around the highway?
Okay. Yes, we do have quite a number of traffic offenses at Mavoko Law Court, particular, and the most notorious, where I would say would be an area that creates concern most of the time, is the weighbridge matters. What we have done is that collaborating with the in charge of weighbridge, we always insist that these matters should be processed at the earliest opportune time, and we take pleas, for instance, from the police station we want them to be processed as fast as possible so that we cut down on any time where, someone would have that opportunity to move around. So we've done that, and it is working fairly well, Chief Justice.
Thank
Yes.
you. Commissioner Mwansa.
Thank you, Chief Justice. One of the leading cases in judicial review of the powers of the then Attorney General, now maybe the DPP, is the case of Stanley Githunguri versus Republic. I don't know whether you've had occasion to read it. It was almost a required reading for everybody who went through undergraduate.
I believe I've come across the case, Commissioner, but
Yes.
I don't quite remember the facts.
Oh, you don't remember the facts?
Yes.
Okay. Now, I want to read for you an excerpt from the case. Actually, it's one of my favorite judges from the old. He says, and I quote, that the applicant is an accused man. The public mind is an impressionable organ, and the morbid usually attracts. The public, in order to establish their own social values, like to find out by comparing themselves with an individual who has come into limelight or whatsoever, and who appears to be a cut above them, whether wholesomely or unwholesome. How such a person is treated in a court of law, whether more or less than a common citizen, is important. So the first question I want to ask is, does it matter to a court how a high-placed individual in society comes and how you treat them? Say if a deputy president came to you, or a governor, or one of the people who hold high positions in society, and they're seeking justice, do you think that it matters how you treat them, or either way every litigant is the same?
Thank you, Honorable Commissioner. To my mind, it does matter how we treat them, in the sense that if they are presented in court and you appear to give preferential treatment, it will not augur well for the other clients that would be waiting for to be processed in court. And so it is important for court to be impartial, fair when dealing with litigants.
Okay.
So that in any given situation, you must demonstrate impartiality in handling a matter.
Okay. Now, one of the principles of that case was on the power that is exercised by the prosecutor to prefer a charge. In summary, if a Kenyan comes to court and says that they are being oppressively charged by the DPP, what would you consider for you to engage, before you make a determination on whether or not the DPP has exercised their power in a constitutional manner?
Thank you, Honorable Commissioner. In that case, I would consider whether the DPP has acted reasonably. I will consider whether the DPP has given a chance to this person to explain himself. I will consider whether the action being taken by the DPP is proportional and appropriate.
Okay.
The circumstances.
All right. Thank you. That's all.
Thank you, Honorable Commissioner.
Thank you, Honorable Chief Justice. Honorable Ojoo, one question from me. The right to liberty is one of the fundamental freedoms that is enshrined in our Constitution. There is a petition that has been filed in your court, you sitting as a High Court judge, whereby someone who had been arrested because she owed money and the matter had proceeded to execution stage and a warrant of arrest had been issued because she failed to appear in court to attend to the notice to show cause. And she has come before you, and her complaint is that Section 38 and 40 of the Civil Procedure Act, these sections sanction deprivation of liberty, and her prayer is that those sections be declared unconstitutional. How would you handle such a matter?
Thank you, Honorable Commissioner. First of all, the right to liberty, of course, can be limited, and the Constitution provides that it can be limited by law. And in these circumstances, this is a person who is a subject of an execution process, which is provided for in law. And so if the person had been given sufficient opportunity to answer to the notice to show cause, I would find that the action of the issuance of warrant of arrest or being detained is proper, and it is provided for in the law under Section 38 and 40. So I would dismiss that petition.
Thank you for that answer. Any other international instrument that you are aware of that guarantees the right to liberty?
International, come again, Honorable Commissioner.
I'm asking if you are aware of any international instrument that also speaks to the question of the right to liberty.
The one that comes to my mind, Honorable Commissioner, is the African Charter on People's Rights. And I don't quite have the name correctly, but I know there's an African Charter on People's Rights and Liberties.
Are you sure that it speaks about liberty?
It's the one that comes to mind, but perhaps I'm wrong.
All right.
Yes.
All right. I think after this interview or in the course of time, you can check on the International Covenant on Civil and Political Rights.
Thank you, my lady.
I'll come back, Honorable Chief Justice, after my colleagues are done in respect of the one complaint that we have. Thank you.
Thank you, Honorable CJ, and Mheshimiwa, once again, welcome.
Thank you, Judge.
Two issues. One is just a clarification on, if I got you right. You talked about a way of curbing corruption at the station by taking pleas at the police station. Did I get you right?
Yes, you did.
Okay. I mean, how is it?
There's a bit of a background to that, Honorable Commissioner, because at Mavoko Law Court, we still have a lot of challenges in space,
Yes.
with space.
Yes.
And after we were advised by the Honorable Chief Justice to do away with temporary structures,
Yes.
we found ourselves with only one courtroom. So 5 of us at the court, we cannot be able to use that one courtroom all at the same time, or even, 2 or 3 of us in a day. So one of the strategies
Yes.
that we have adopted to help us with, dealing with the cases is to take plea online. And I thank my court users because they have been very, very supportive. We have done this for almost 3 years now. And it works very well because we have a dedicated online forum for that. All our stakeholders are aware of it. The stations have adapted to it very, very well because it even saves them time of moving around with the
okay, so if I get you right, Honorable, it's the virtual system.
Yes, it's a virtual.
Okay, I thought you physically walked to the police station and I wanted to understand it well because it may have a positive impact on the fight against the vice.
Okay.
That aside, how would you handle conflicting decisions of a superior court when you are handling a matter and that comes up?
Thank you, Honorable Commissioner. Yes, this is an issue that arises and it is with us. When you encounter conflicting decisions, normally I look at the circumstances of the case, and while interpreting the law, I will most likely adopt the decision that aligns with the matter before me in the circumstances.
Yes. Any other consideration?
Yes. Apart from that, I would also use international statutes that would go along to support my position or my finding or the decision that I'm relying on.
Okay.
Yes.
Thank you. I wish you the very best.
Thank you, Honorable Commissioner.
Yes, good afternoon.
Good afternoon, Madam Ojoo.
You may agree with me or not, but I think that public interest litigation has increasingly attracted professionalized litigation structures. In your view, what doctrinal or remedial interventions can courts deploy to ensure that public interest litigation remains a tool for constitutional accountability and less prone to abuse?
Honorable Commissioner, can I request that you come again, please?
Public interest litigation has increasingly attracted professionalized litigation structures. We find professionals now, people who are just professional in public interest litigation on behalf of parties. And sometimes in those instances, individual interests are camouflaged as public interest. I could be right or wrong. But in your view, what doctrinal or remedial interventions can courts deploy to ensure that public interest litigation remains a tool for constitutional accountability and less prone to abuse?
Thank you, Honorable Commissioner.
You want me to paraphrase still?
Kindly.
You know about public interest litigation?
Yes, I do.
And sometimes, most cases, it is in the public interest. Before assuming jurisdiction of a matter framed as public interest litigation, what minimum substantive or procedural threshold should courts insist on?
Thank you, Honorable Ojoo. One of the tests that the court would be applying is to confirm that the litigant has an interest, a stake in the subject matter, that the litigant is acting on behalf of persons directly affected by the matter. And that
I'm confining to myself to the one that is coming in the public interest, meaning that it is in the interest of the whole public, not an individual. How do you define public interest?
Public interest is public interest litigation is where a suit or a claim has been, or a petition has been filed to pursue a matter that would be considered beneficial to a certain class of people or a certain area or residents of an area or persons.
So in cases where we think that public interest litigation has been misused, not to achieve the intended purpose, but for other personal or non-constitutional purposes, how should the courts guard the door to public interest litigation?
I believe the petitioners must always establish locus in a matter so that the court can consider whether he or she is properly before the court to pursue that particular claim.
I agree. So what I was asking, when determining locus, what do you think the court should have in mind? Whether this person is properly before the court in the public interest.
What comes to mind, Honorable AG, is that the person or the litigant has to establish a nexus between him being before court and the subject matter or the substrat of the substance of the matter before the court.
Okay, thanks.
Thank you, Honorable AG.
Thank you, Chair. Good afternoon, Your Honor.
Good afternoon, Commissioner.
Do you want some water?
Yes, I'll have
Please
a sip.
go ahead.
Thank you, Commissioner.
Okay. I have gone through your sample writing, Your Honor. You shared with us decisions in children, criminal, divorce, employment, and land matters. And looking at them, you demonstrate competence in issue identification, structured legal reasoning, and consistent application of statutory and constitutional principles. You're able to link facts to applicable legal standard, and your decisions are supported by relevant precedents. I remember the last time what you submitted, you had not made any reference to case law. So
I remember that.
commend you for that, and the tone is measured and professional. So I commend you for that.
Thank you, Honorable Commissioner.
So under Article 27 of the Constitution, discrimination is prohibited, any form of discrimination. But at the same time, Article 32 protects religious freedom. So how should a court resolve the dispute where religious practice or belief appears to conflict with the constitutional provision of equality? And maybe a case in point would be the role of women in leadership in churches. Yeah.
Thank you, Honorable Commissioner. Yes, Article 27 of the Constitution provides for, prohibits discrimination.
Yes.
At the same time, Article 32 provides for freedom of conscience, religion, belief, and opinion. So your question is, Honorable Commissioner, is how do you distinguish?
How do you resolve a dispute that affects both rights? So a person comes to you, a woman says that I have been denied the right to take up leadership positions in a church. And then the church says there's the issue of freedom of religion. how do you resolve that particular issue that appears to, quote unquote, be conflicting?
Okay. So yes, equality is guaranteed, and when someone joins a particular religion or a congregation, they submit to the dictates of that religion, and so a person cannot again turn to say they have been prohibited to exercise certain rights under that religion that they willingly subscribed to. And in this case, I would think of if it would not be an issue of inequality, it would be an issue of differentiation, whereby the religion gives its own dictates, and the person who willingly subscribes to the same should be able to adhere to those dictates.
Okay, thank you. Looking at feedback from members of the public, they say that you're a mentor and you give opportunities to other staff to make their decisions and you guide them well. They also say that you're firm and you're time conscious, you're a good listener, and they also indicate that you're a person of impeccable integrity. However, there are those who say that you're not so firm when it comes to supervision. And you find there are some staff members who engage in corrupt dealings within the court, and you cannot address that particular issue. I think there was a time there was complaints with regards to how certain county officials were getting favorable orders within the court. And then there is also a judicial officer who issued notice that she'll be away on sick leave, but proceeded for about 1 week, but proceeded to hear matters during that time, despite the notice being out. So the issue of supervision, not you as a person when it comes to conduct, but you as a supervisor.
Thank you.
Managing your team, yeah, and ensuring that they do the right thing.
Thank you, Honorable Commissioner. Yes, managing a team is very important for a leader. On my part, I must say I am firm. When it comes to supervision of staff in this particular situation, there's a bit of context to it, Commissioner, because where we are operating as Mavoko Law Court, we are being housed in at the sub-county offices, so we are a bit scattered in the place where you find that the one office is in another building, while the other one is about 200 meters away or something like that. So we are a bit scattered where we are right now, although I must thank Commissioner Olwande and the CRJ. Thanks to them, we are almost moving to our own court. So currently where we are, because of the scattered nature, and then we are right in the middle of the offices used by the sub-county officers and their enforcement officers. Sometimes it's a challenge managing the staff, because you can't tell where they are. You almost can't tell where they are sometimes, because you are in court and they are in a different location. So it becomes a bit of a challenge, because we don't have CCTVs for me to see where someone is at any particular time. But it is something that we address in every staff meeting. Every staff meeting, one of the standing agendas is corruption and absenteeism. So we talk about these things But by human nature, sometimes you really can't tie someone down to the desk. But the big challenge about Mavoko is because of the way we are scattered.
Taken like any action, had a disciplinary process commence against them, like sending the complaints to CRJ or Ojoo?
Yes.
Where appropriate? Okay,
yes.
Thank you.
Actually, there are 2 active cases.
Okay.
Yes.
Thank you.
So we've taken action.
Thank you and all the best.
Thank you.
Thank you. Can a state officer be a member of a political party?
Thank you, Honorable Commissioner. A state officer can be a member of a political party but not hold office.
Okay.
Yes.
And is there a difference between those state officers who are appointed and those who are elected?
I want to believe there's no difference, because at the end of the day, they take an oath of office and they are subject to the same. Should I say statute? They are subject to the same code of conduct when it comes to execution of their duties.
Okay.
Yes.
So, when you look at Article 38, which gives every citizen has political rights, the right to be a member of a political party, the right to be official of a member party, is there good reason that state offices are restricted, or that right is limited for state officers who are not elected? Is there a good reason?
There is a good reason, because if they were led to express or to even be leaders in a political party, for instance, the danger or the mischief there would be that they would be likely to use their status to influence matters.
So if they are officials, but what if they're just members? What if I'm a judge and I'm just a member of a political party? How will that give me a platform to influence?
Okay, to my mind, unless you openly express your membership or your support for the party with an intention to benefit from it, but just being a member is okay. I mean, it's not prohibited.
Thank you. You have answered my question.
Thank you.
Thank you, Chair. Good afternoon once again, Mheshimiwa.
Good afternoon, Honorable Commissioner.
I'm glad to hear we are about to complete that project. It's very close to my heart. Please, the day you're moving, invite me for the party.
I will, Commissioner.
Yes. I want to engage in a brief discussion with you concerning your DISPOP report on performance. I don't know if you were furnished with a copy.
Yes, I was.
And it's accurate?
It is accurate.
It is accurate. Okay. Your report is quite good. I must commend you for that. It shows in your report about 4% of your cases are what comprise backlog. Most of your cases are current. So what you said in your introductory remarks is borne out by your report. I see your case clearance rate is right on mark with the national average of 104. I want to commend you strongly for the court productivity. I see you are doing 931 against 370. This is quite commendable. And also, in terms of your own performance, you are quite on the mark. What is expected is 25, and you are doing 25. That's great. What I wanted, maybe, I have no quarrels with you. I'm actually very happy with your report. But what I wanted to maybe ask you, what are the strategies you have engaged, which you will carry to the High Court, to ensure we have good court productivity and also case clearance rate. I'm giving you a moment to shine. All the best.
Thank you, Honorable Commissioner. And perhaps I should mention that having taken from you, I took up the mantle from where you left it, and we have continued walking in your shoes. So what we do to achieve this court productivity rate, of course, we do proper case management, number one. Number two, part of the strategy is also to have manageable cost lists. Number three, we normally do what we call bottom-up sieving of the cases, whereby we try as much as possible to have the more complex matters being handled by the more experienced magistrates. Not that we deny the other magistrates' work, but we always feel that the more experienced magistrates should have the more complex matters. That way matters will move when we give a magistrate the right kind of load to bear. So you find that matters move much faster that way. The other strategy we have is that we ensure that all matters are captured in the CTS so that we don't have any case that is hanging. We do regular case audit. We also do, as a strategy to fight the backlog that we had for the WIBA matters, the matters we fondly refer to as WIBA matters, we had regular service months for the WIBA matters. Like every quarter we would have a service month for the WIBA matters. So we found that that also helped in moving the matters. So those are a few things.
Okay, thank you very much for the strategy. I can see they actually paid off. And much as you flattered me, you've done better than I did while at Mavoko. All the best, and I wish you well. Thank you, my lady.
Thank you, Honorable Commissioner.
Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
Now, could you tell us some of the key elements of an independent exercise of judicial authority, and tell us how you have applied these elements?
Key elements?
Of an independent exercise of judicial authority by a judge. That is Section 7 of the Code of Conduct.
Thank you, Honorable Commissioner, for that question. Independence for a judge or a judicial officer is very important, and the key elements that would indicate independence is transparency in the manner someone conducts himself, impartiality in the manner someone conducts himself, fairness, both in the decisions they make and in how they relate with others. Okay, those are the three that come to my mind right now.
That's fine, but how have you applied them?
Okay. When it comes to transparency, I believe I am transparent, and I embrace transparency, and even in my decisions, I deal with the parties fairly. I give them a fair opportunity to present their case, and I make a decision based on the facts and the law. On fairness, which is closely related to impartiality, I also endeavor to ensure that parties are treated fairly when they come to court, and with no preference for any class or sex or gender, we endeavor to treat them equally when they are before me.
Okay, fair enough. Thank you very much. I wish you all the best.
Thank you, Commissioner.
Thank you. Now, what do you consider the most pressing global challenges today, and how do they affect national institutions like the judiciary and the public service?
Thank you, Honorable Vice Chair, for that question. What comes to mind on the most pressing challenge globally today is the fast pace that AI or internet is evolving and being used, and we are finding ourselves trying to catch up. The race is on. Things are moving very fast globally in that area, and we are left to catch up. And this, if we talk about the threats this poses to institutions like the judiciary, I would say you would find that we may have systems that are not coping with the rate of development, so that our systems could be weakened or infiltrated easily. So for me, the fast pace of development in the internet is something that we need to watch over and try and see how we can catch up.
Thank you.
Thank you, Honorable Chair. Honorable Barbara, I was to come back to you in respect of one complaint which you are made aware of, and you made a response. Now, this is a matter that you are handling, and the complainant in this matter was a tenant. She faced a threat of being evicted, and she came before you seeking an order that you injunct the landlord from evicting her. You did grant the order of injunction, a conditional actually order of injunction, and asked her to deposit a sum of 35,000 shillings within 5 days. Immediately thereafter, she came back to court, filed another application, and she was seeking that you certify that matter as urgent because she wanted a mandatory order to have the landlord reconnect water as well as electricity. Now, you did not certify the matter as urgent, and her complaint was that her baby, who was 3 months old, suffered in that you did not take into account the best interests of the child. I know that you've responded and you have said that you handled this matter based on the facts and the law, and that as far as you are concerned, whatever decision that you made was really merit-based. Maybe you could say one or two things about this?
Thank you, Honorable Commissioner. Yes, indeed, I got the complaint yesterday and I responded yesterday. The matter is still live, one. Two, this person, as you correctly put it, Commissioner, when he came, it's actually a he.
Okay,
when
sorry.
Yes,
okay.
Yeah. When he came, of course, he laid out his case, and I could see from his pleadings that it's a dispute of rent arrears. So I gave him the conditional, the conditional order, because, based on the facts, Among the things he was proposing was that he be given time to clear the rent arrears. And so I said, as a show of commitment, and because I haven't heard the other side, please deposit some amount. I will give you the order, but please deposit some amount. Because I also have to take care of the interest of the other side, even though they are yet to state their case. So I did that, and he went and served. And the funny thing is that on the eve, or about 2 days before the hearing of the application, he filed the second application. So on the day of the hearing, of course, the respondent had not been served with that application. But the most important thing is that he had also not complied with the condition that I gave. And so I explained to him that, you are in court. This is a matter between two parties. I'm the referee. I gave you certain conditions. Please go and comply, because the landlord had actually complied. He has not evicted you. So I made it clear to him that, when you're coming before court, your hands should be clean. And I made the order in the best interest of both parties. Of course, at that time, there was no issue of the child. The issue of the child is being introduced in this complaint, unfortunately, because at that time, his complaint was that the landlord had not repaired some surface in the house, and that's why he was refusing to pay rent. But you see, Commissioner, up to now, he has not complied.
How much rent is outstanding?
It is now about 70,000, because he stopped paying in October last year.
So how much,
and then
how much
he was
is it
given
per month? Do you know?
10,000.
10,000.
Yes, but he had also, according to the affidavit that the landlord brought, he had also defaulted much earlier. And he had defaulted also on payments of utilities like electricity and water.
Those are separate from the rent?
They are separate from the rent. So, unfortunately, that is where his case is. It's just that he has not shown some goodwill on his part, because the landlord has really tried. In fact, the landlord is represented, and every time they come, the advocate is quite accommodating. And the court has also been accommodating. I told him, please, at least show some commitment. You cannot be in someone's house and you want also the law to be on your side and you're not doing anything. So that is my view, Honorable Commissioner.
All right. Thank you.
So, looking at this complaint, initially you gave an injunction. It was ex parte. He says, my landlord is about to evict me, and you say, okay, you're not evicted, but you need to deposit. It's a conditional, there's a condition to it.
Yes.
He then comes to you later and says, maybe a month later, yes, he has not complied with your condition. That relates to the prayer to prevent him being evicted. He comes now again with an application. The prayer is different. The prayer is, the landlord has disconnected the electricity and the water. Can you give orders to tell the landlord not to cut my electricity and my water? You don't address it. You don't consider it urgent. Until today, actually, you have not actually settled that question. So I worry that then perhaps, it sounds to me that there is a possibility of constructive eviction, where, yes, you have given an order for the landlord not to evict, but actually, because there is no power in the house and no electricity, it's a constructive eviction, which you have not addressed. That's the first case. Secondly, that you are mixing the prayers. So there is a prayer for one thing, which you have granted with a condition. That condition has not been met, but somehow the fact that this condition has not been met for the first prayer, you are now applying it to behavior of the applicant on the second prayer. I'm not sure that you can connect them. I'm not sure if you can connect them that way. But also, finally, I'm concerned that this is a matter still ongoing, but you are already expressing which of the parties you think is doing what the court has said. I'm not sure. I understand we are asking you about it, but I don't know how now, having publicly stated that you think one party is doing this and that, I'm not sure how you proceed with the matter. But if you can just answer those questions, as particularly the one of constructive eviction.
Thank you, my lady. May I start with the last point, kindly, about mentioning the matter and almost expressing my position. It is on record that the complainant has not complied with it is on record, and it does not dispute that. So he's still in the house. That is a fact, and he has not complied with the order. Now, on the matter of constructive eviction, I do see your point, my lady, but these are utilities that the landlord has no control over. You remember I said he's actually paying these utilities not to the landlord, but to the provider. So if Kenya Power came and disconnected because he's not paying, I don't think it would be proper to order the landlord to reconnect him, to reconnect the service. So as it is, he has defaulted both on the rents as well as the utilities. And the landlord definitely is not the person responsible for the water connection and the power connection. It is a totally different entity. So that is the way I'm looking at it.
Okay, thank you. It's just that according to the documents that we have here, it appears it is the landlord who disconnected the electricity and water, and sometimes it happens that the landlord is the one who is in control. Perhaps you look at that. Sorry.
Yes, sure, I'll look at that.
Thank you. I do not want to dig into that, but the way you have demonstrated your ability to case manage, since this a case you'd have dealt with on the spot. I mean, let him get on the witness box and say what is his claim, and the landlord gets there, and within 3 months you are done with this matter. What is it filibustering in your court doing? Where there is even no dispute, I haven't paid rent. Yes.
Thank you, Honorable Chief Justice. Indeed, that was my way I was looking at it. But then this is a litigant who, it has now come to my knowledge that he tends to file matters just on the eve or 2 days to the hearing. Like his first application, when it was coming for hearing, he filed the second application 2 days to. And then, of course, on the day of the hearing, now it's a challenge because the other side has not been served, and the advocate is saying, please, I also need to respond. Then you find, I have to give the respondent time to respond as well. Then it comes again for hearing. Like, I'll be honest, they were before me on Monday, on 23rd. They were before me. On that day, again, he had filed another application.
So you cannot give directions on the way to dispose of this matter. And because you are a firm JO, known for your firmness, you can't firmly give directions that I want to hear the substance of the matter on this day, and you proceed.
I have done that, my lady, and I gave them hearing on 11th. After I'm done with this interview, I told them I will hear this matter and I will decide on it on 11th of March.
Okay, very well. I think this brings, another.
Just checking, is this a matter you can proceed on after a complaint against you?
Yes, that's a challenge. It would perhaps, with the concurrence of the parties, I'll probably give it to a colleague to deal with it. Yes.
I think it's better that way, especially now that you have been discussing it publicly.
True.
So I think this brings us to the end of this very engaging interaction with you, Honorable Ojoo. But we always give a candidate also an opportunity to engage us. Yes, you have the opportunity.
Thank you very much, Honorable Chief Justice and Honorable Commissioners. Like I said, it's an honor to appear before you today and to have this conversation. I do not take it for granted. Secondly, perhaps, and this could be maybe an operational issue, picking from the point that the Vice Chair raised on, fast pace of, on the global trends, global trends that would affect the institution. The issue of AI and, the way it is developing. I thought, and I've been thinking about this and applied my mind a bit on it, if we could get an AI triaging tool at the point of filing on the CTS, it would go a long way in helping with the case management. A triaging tool, because if you remember, we've removed the human interface at the point of filing. And so you find that sometimes matters are filed when maybe it's from the wrong jurisdiction, or someone has failed to pay the full fees. And so if we had a triaging tool at that particular point, we would weed out some matters. We would weed out some matters at that point, and then, of course, cut down some time spent on case management. So if we could have a good triaging tool at that entry point, it would help. Chief Justice, thank you very much.
Yes, we noted, point well noted, to be shared with the ICT Directorate, because we are always looking for innovative ways of improving our service delivery. So thank you very much for that insightful thoughts.
Thank
how
you.
to improve on technology. Yes. I think on behalf of the commissioners, we want to wish you success, and we will get in touch with you when we complete this very competitive exercise. Meanwhile, we wish you all the best. You are in the service of Kenyans, so always put the best foot forward for Kenyans.
Thank you, Chief
Yes.
Justice.
Okay.